Good morning, this is your Kelso Report for Monday, September 17th, and I'm your host, Clark Kelso. Our cases today include reversal of a criminal conviction when the government, in bad faith, deported an alien who the prosecution knew was able to provide exculpatory evidence to the defense. And we also have a state law paternity proceeding where the alleged father unsuccessfully tried to assert a privacy interest in choosing which laboratory would test his DNA. We begin with the Ninth Circuit. The Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. That is the lesson of the Sixth Amendment's guarantee of compulsory process and the Fifth Amendment's guarantee of due process. In United States v. Leal del Carmen, the United States denied the defendant that meaningful opportunity by deporting an illegal alien who the government knew from its interview with the alien could provide exculpatory evidence for a criminal defendant. By deliberately and in bad faith putting the defendant's sole favorable witness beyond the reach of the court and defense counsel, the government violated the defendant's rights, and his conviction, therefore, was reversed. Our next case today involves family law and privacy rights. That was the focus in County of San Diego versus Mason, where the sole issue was whether, in a paternity determination proceeding, where the government bears the burden of proof, an alleged father has a constitutional right to prevent a government-contracted laboratory from conducting a paternity test, and to instead select a private laboratory to conduct the test. The privacy interest being asserted in this case was extremely narrow. The alleged father did not object to the physical intrusion of a DNA sample being taken from his person by buccal swab. He also consented to the use of his DNA for the limited purpose of determining whether he was the father. And the county did not contest his right to have a private laboratory of his choice conduct a paternity test, and if the results differed from those of the county's laboratory, to present the different results to the court as conflicting evidence. So, in light of the very narrow issue presented and the lack of any evidence at all that a county-contracted lab would be more likely to infringe upon the alleged father's privacy than any other lab he was going to select, the 4th District had no trouble at all in deciding that the county had a compelling interest in using one of its labs to conduct a paternity test as part of a contested paternity determination. In short, you don't get to choose your lab. That's it for today's Kelso Report. Have a great day in the law.